Now to our focus for tonight. A few weeks ago, precisely Thursday, July 7, 2023, the Federal High Court in Abuja disqualified the governorship candidate of the People's Democratic Party in Delta State, Rt.Hon.Oborevwori, from contesting the 2023 election. The judge, Taiwo, ruled that Oborevwori was not eligible to contest the governorship election in the state because it supplied false information to the Independent National Electoral Commission, INEC, to back his nomination as his party's candidate. The judgment was on a suit filed by David Edewe, a former commissioner of finance and a former governor James Ibori's administration, alleging inconsistencies in the names on the academic certificate submitted by Oborevwori to INEC. Edewe came second behind Sheriff Oborevwori in May 25, 2022 governorship primaries of the PDP in Delta State. He sued Oborevwori, PDP and INEC as first to the third respondent respectively. According to the plaintiff, Oborevwori used the names Oborevwori Sheriff Francis and Orodwedo interchangeably in his certificates submitted to INEC in violation of the Nigerian Constitution and Electoral Act. He contended that Oborevwori was not eligible to participate in the primary election on grounds of alleged discrepancies in his academic qualifications. I'll bring you documents also, from INEC to show what we are talking about at this point. It is, however, on record that the electoral umpire INEC has written to the PDP, drawing their attention to the judgment order of the Federal High Court of Nigeria, Abuja, to the suit. The commission said it is hoping that a party, that is the PDP, takes note of the judgment order. We shall further revisit the implication of that judgment to the forthcoming election, especially in Delta State, in the course of our interaction tonight. But it is noteworthy to bring to your knowledge that on the 20th of July 2022, on Democracy Today's edition of the program, a lawyer, barrister Libros Oshoma, tried to make sense of the issues arising from the judgment. But tonight, another lawyer, Barrister Victor Ebonka, shall be giving his own perspective to the matter. Good evening and good to have you join us. Barrister Victor Ebonka is the chairman, Ika Northeast Local Government Council, chairman of Algon Delta State Chapter, and a national legal advisor, Algon, in Delta State. He is also a member of the People's Democratic Party.
Thank you.
Yeah, good to have you join us. We'll go straight to the conversation. What is going on within the PDP in Delta State? Because for some people, the party is at the verge of not having a governorship candidate.
That is not correct. That is not the true position. It's a very popular party in Delta State, and because of its popularity, there's bound to be one issue or the other, because we just had our primaries. The aggrieved parties, one of the aggrieved parties took the candidate that won, Sheriff Oborevwori, to court, to the Federal High Court. The court only recently ruled a few days ago erroneously. That is what necessitated my coming here to bring the facts before the viewers and before the other members of the public, as against the outright falsehood that is being dished out to members of the public. You know, the case against Sheriff Oborevwori was predicated on Section 29.5 of the Electoral Act 2022, which is in pari material with Section 31.5 of the 2010 Electoral Act, for which the Supreme Court has decided on the issues that was also decided in the law court. And is principally based on the fact that Sheriff Oborevwori supplied and submitted false information and forged documents to the party for clearance or nomination, as the case may be. But the fact of the matter, I wouldn't want to go to the technicality of the suit being premature. I'll talk about that later. But I want to go to the merit of his certificates and his age. It is their case principally that he forged his WAEC certificate. And the basis of arriving at that conclusion is that on the face of the WAEC certificate, it has a date of birth, 1979, in relation to his declaration that he was born in 1963. And this error in this WAEC certificate has been corrected by him, by an affidavit sworn to in 2003, correcting this error. Okay, assuming but not considering that this error is not corrected, can an error in age be a basis for concluding that a document is forged? Apparently no, there is no law to that. If the argument is that he was about 36 years when he sat for the exam, is there any law placing a time limit within which you could sit for anybody could sit for any exam, or within which anybody could decide to seek for more academic qualifications? Definitely no. And what is the position of the Supreme Court in this? Aki versus PDP. You understand me? Aki versus the Supreme Court heard that disparity in age and all that put together. As at the time he ran for the election, is he up to 35 years, the qualification age? Yes. I'll still come back to that. Still on that WAEC certificate, they admitted in their originating summons that his name is in the portal, that the WAEC certificate, the certificate they are alleging was forged. Because for you to allege for, you need to place the original from where the forgery took place. That they have not done. They admitted that the WAEC certificate is in the portal of WAEC. And his photograph is there, his passport is there in the WAEC portal. What is the evidential standard of proof required by law? The Supreme Court has heard in APC versus Elebeke several authorities, Dantiye's case and others, several authorities, that the only authority to say that a document is forged is the issuing authority. That's the authority that issued the result. And in this case, that is the WAEC. And they have not come to show us that this is a document we wrote to WAEC to authenticate this result. And WAEC has replied us to say that the document is forged. They have not come to say, and the court is drawing a conclusion on the basis of that. That is for the WAEC. I'll provide the case law on all these issues in the course of this discourse.
You know, there is another argument, you know, in spite of your postulation right now, the allegations before the plaintiff, or rather the defendant, is that there are inconsistencies with his names, you know, on his academics certificate submitted to INEC. You know, for some people, some of the certificates had Oborevwori, Sheriff Francis, while others had Oborevwori interchangeably.
Thank you.
How are you able to prove?
Thank you. Like I said earlier, there is nothing novel about Sheriff's case. There have been similar situations as this. And the Apex Court has interpreted the position of the law today in distinguishing those situations from Deji's case and Sheriff's case from Deji's case as well. We have the case of Elebeke, Ibezim versus Elebeke. We have the case of APC versus Dantiye. And I'll tell you what the Supreme Court said about. When there are mere misarrangement, when there are mere misarrangement of names as this, Supreme Court said it holds no water, except you go to prove that that name is being answered by somebody else, and that is not the case here. Except you go to prove that those names were is intended for fraud, and that is not the case here. And don't forget that by birth he was given the name Francis Rt.Hon.Oborevwori. And because his uncle affectionately called him Sheriff, and Sheriff became so popular and commonly known by people, he did, in 2023, he deposed to an affidavit in 2023, changing his name, adding Sheriff to his name and Rt.Hon.Oborevwori, to the effect that he should be known as Sheriff Francis Rt.Hon.Oborevwori. And he had same published in the January 30th of Nigerian Observer, 2004. In less than 1 year of the affidavit. And all these incidents happened 18 years ago. Would he have been said to be preparing his grant to commit fraud in the next 18 years? Apparently no. Happened long ago, even before he contested and won the election in 2015 and 2019 to the House of Assembly to represent his local government. All this incident happened.
You have cited a number of precedents And I would give you this precedent. I will cite my own precedent. I will
Yes.
take you to the
But
case
I
of
have not
Bielsa.
concluded before you interjected, but I'll still go back and conclude.
I'll
Thank
take you to the case of Bielsa. You know, a lot of people have this concern
Yes.
that the outcome, the possible outcome of the election in 2023 might be, you know, more like what we had in Bielsa.
Thank you. Thank you. That is where I was going to before you interjected. In his own case, he went further to execute a deed poll, reconciling all these names and affirming the fact that as they appear in my certificates, they are my names, they are my certificates. But I wish to be known now as Sheriff Francis Rt.Hon.Oborevwori, giving a necessary explanation and creating the necessary nexus between those certificates and himself. That completely distinguished it from the case of Deji's case that you're talking about. In Deji's case, what is the situation there? The scenario is totally different from the scenario in Sheriff's case. In Deji's case, 3 different names that are unrelated. He answered 3 different names in his 3 different certificates that are unrelated. Even in his nomination form to the party, to APC, a totally different name from that, which is distinguishable from this. Don't forget that in all these names that we're talking about, the given name, Francis and Oborevwori, reflects in all these 4 certificates. It reflects. So the mere arrangement of the name is the issue. And the Supreme Court has rightly heard in Dantie's case and Ibezim Elekebe's case that it holds no water, except you go to show that somebody else is answering this name. There's a sufficient nexus between him and he has sufficiently explained it in the deed poll, even in the affidavit. To me, the deed poll is even a surplusage on his part. Because nobody else has come to say that this name belongs to me, or this certificate belongs to me, or that belongs to me. You understand me? That is the case. And not until somebody else comes to say that this certificate bearing this name different from this one is mine. That is the position of the Supreme Court. If in the absence of any of those evidence, the name belongs to him and he holds no water.
Now, contrary to your viewpoints, on July 20 edition of Democracy Today, a lawyer, barrister, Libros Oshoma, who seemed to be well aware of the issue in the PDP in Delta State, was on this program. And he also gave his own narration and perhaps made sense of the judgment of the Federal High Courts. You listening, I'm very aware you're listening to that interview, and you feel he did not give the true situation of things?
As lawyers, we are trained to talk factually, not based on sentiment that is in the public. Place your facts, the whole of your facts. As I was coming to here, I came.
But according to some people, he was very factual. I mean,
no, he was not. I don't
How
really,
so?
with due respect to him, he was not factual in his conclusions. He made some derogatory statements with regards that they all know each other in Warri now. So a lawyer shouldn't talk like that. That's why I don't really want to go into that. You know me before, I was not as rich as I am now. And subsequently, God elevated me to the position of being a candidate of the party. Does not make me not to be qualified to be a governorship candidate and all that. Those are sentimental words that I don't expect a lawyer to speak in under such scenario. But however, I don't want his issues to waste my time. One of the issues that he raised that I want to point out is on the deed poll. One of the exhibits exhibited, wherein he read the judgment of the court, where the court stated that the exhibit was stamp duty in 1979, whereas the deed poll was made in 2011. That is not the truth. I have the deed poll here. That is one of the reasons why we are going to Court of Appeal. The court just concluded on the basis of what is not before him. The deed poll has a stamp on it, and the stamp is clearly stated to be 2022. And when you go before a stamp duty, they first of all do what is called checking beside. The checking beside bears 2022, and the stamp duty of the bears 2022 clearly stated. But the court erroneously held that it bears 1979, which is one of the issues he raised. And on the basis of that, the judge concluded, unsubstantiated conclusion, and his judgment became so perverse and occasioned gross miscarriage of justice. That is why we are on appeal. You know, outside that, Haven't said about the names.
And are you confident?
Yes, very, very confident. Very, very confident. I decided to deal with these issues on the merit without going to the other technical issues that has already knocked off their case. Their case is dead on arrival, ab initio.
Please, could you tell our viewers the technical issues that
the technical issue
knocked off the case?
Yes, under session, their case was predicated under section 29(5) of the Electoral Act 2020, which is in pari material with section 31(5) of 2010 Electoral Act, for which the Supreme Court have decided a whole lot of cases. Modibo versus Usman is a case on this score. Ibezim versus Elekebe, even in Dantie's case, even in Atiku's case and all that. Supreme Court has consistently maintained that for the course of action to accrue to you, the name of the candidate must have been submitted to INEC. And his affidavit, where you are alleging that false documents were attached or made, must have been submitted to INEC. And then INEC must have published same. Then you apply to INEC. You apply to INEC for these documents before you have the cause of action to sue. In the absence of that, there is no cause of action. He sued before the publication was only made yesterday. He took us to court before the publication, far before the publication, which makes his case very, very premature and speculative. And that is the law. Supreme Court has consistently maintained that. Then, going back to the burden of proof, in the totality of his case, he's alleging crime. There is allegation of crime.
And the onus is on
forgery. And that is what I'm talking about. He's alleging crime, allegation of crime. And when there is an allegation of crime in a criminal proceeding, it must be proved beyond reasonable doubt. Section 135, 1 and 2 of the Evidence Act. And in proving beyond reasonable doubt, you need credible, you need cogent, you need legally admissible evidence and proof. And all that are lacking in their case. And the kind of proof under this head is not the kind of proof you do on the basis of affidavit evidence. You must call the issuing authorities. You must call those that made the law. You must call those that issued the certificate to come and say, this certificate, this man sat for this exam, or he did not sit for this exam, or this certificate did not emanate from us. All that is lacking in their case. Whether or not we even counter it, or whether or not it was countered or not, you are not going to succeed on the weakness of the defendant's case, but on the strength of your own case. You have the case of on this score, you have the case of Mohammed versus Wamako. Similar to this case, where a case of this nature was initiated by Rt.Hon.Oborevwori. The Apex Court said no, it ought to be by, it was initiated by, and the Apex Court said it ought to be by Rt.Hon.Oborevwori, because they are irreconcilable differences. There are irreconcilable assertions. You said I forged. I said I didn't forge. You said my names are there are disparity in my names. I said these are the reasons why there are difference in arrangement of my names. And the law is that go file writ of summons and call credible evidence in proof of your case. Being a declaratory relief, that's what you have to do. Not ventilating it. A judge will just look at the affidavit evidence and start deciding it. On a case of forgery, no, that is not the law. I want to crave your indulgence. Okay, still on that 29(5). The court construed and interpreted the whole of that session disjunctively. It ought to be interpreted conjunctively, as was the case in the Supreme Court in Ibezim's case. I have the Ibezim's authority, and I would recommend you to read ratio 8 of this case, ratio 8, ratio 2 of this case. I'll leave it for you, so that anybody that comes before you, you have questions to ask them. And that is not the case. Argue versus BTP.
Just like we have questions to ask you.
If you ask me, I will fire back, because I have the facts. I'm a lawyer. I've read the judgment. Though I'm not part of the legal team.
Well, very so. Shoma also had his facts.
It's unfortunate. I don't want to really talk about that because he's eating to my time. I know I'm time bad as I'm here now, but God knows whether he has the power. The listeners, those listening to us from outside, will determine whether he's acting factually.
But while we understand that this is a pre-election matter, yes, there are those who say, who have also interpreted sections of the Electoral yes. Act where when you have cases that are around inconsistencies with names and identification, the result is automatic disqualification?
Yes, only when the inconsistencies are of such a nature that the names are not reasonably, there's no nexus between the names and you. There's no relationship between the names and you that has those different arrangements. Or like in Deji's case, a totally different name on three different occasions. That is not the same with Sherry's case. In Sherry's case, the given name Francis reflects in all the certificates. Oborevwori reflects in all the certificates. And he has deposed to an affidavit. The Supreme Court said you must show that this is intended for fraud. Affidavit deposed to in 2003 before he contested the election in 2015. Can it be said that he's anticipating to commit fraud in 2000? No. The answer is no. There's no fact that it is intended for. It was done in good faith. And he deposed to affidavit to that effect. And there are worse scenarios. In Ibezim's case, it's even worse than his case. And Supreme Court has heard that it is not the case. We have departed from Deji's case. This is our present position, NAPC and DENTA. That you have different arrangement of names and all that does not make you not to be the owner of the certificates that have those names. Except somebody else comes to say that those names belong to me. I am the owner of these certificates. In the absence of all this evidence, you are not going to succeed.
Well, finally,
before you go finally, I crave your indulgence, please, to take you through the position of APC versus Elebeke, as it were. I'm trying to give you the Supreme Court judgment. It was obvious that the allegation of falsification and forgery of documents could not be proved on the bare assertion in the affidavit related to the documents attached to them. Could not be proved on the bare assertion, as was proved in that judgment. It could not be proved. That's what Supreme Court said. It was also obvious that it would be impossible to resolve the irreconcilable disputes on the relevant facts of the state of affairs as they stood. There were irreconcilable disputes in our case. You said we forged. We said we didn't forge. You said these ages belong to somebody else. We said it belongs to me. I have this pool.
That's according to your own.
That is the law. The law is certain. The facts are there. That's why.
Because we know that lawyers usually have.
That's why we have what we call judicial precedence, stare decisis. You follow what the Supreme Court has said. There's no issue that has not been litigated upon by the Supreme Court. There's nothing novel in Sherry's case. Yet the trial court, in spite of all this irreconcilable difference, the trial court proceeded to try allegations of forgery on originating summons, as was done in this case. And the assertions in the affidavit and counter affidavits, and found that the second respondent falsified or forged the documents because the name of the second respondent in some document is stated in a manner or form different from how it is stated in other documents. Similar case as this. Just remove this Ibezim, put Sheriff. Remove the other one. Remove Ibezim, put Sheriff, remove the other name and put Edewere.
You seem to be confident
about. Very, very confident. That case will not stand. The law is there.
Well,
that case will not stand appeal. It will never stand appeal.
I would ask you my last question.
Yes.
Now.
Before you ask me your last question, I crave your indulgence.
Just a minute, please.
Before you ask me.
Just a minute.
Yes.
You would conclude on your point.
Yes.
But I would ask you this question,
yes.
and that is on the basis of popularity of your candidate. For some people, they say one of the reasons why the party is having issues in the state is because of the candidate presented to the people.
He is very, very popular. You know, when you present a candidate that lives in the state, interacts with the commoners, and knows all the nook and crannies of the state, is different from where you present a foreigner, even though he's from the state, that doesn't associate with the people in the state. Somebody that is a snob. Sheriff is his popularity is overwhelming. That's why you are seeing these attacks on him. That is why you are seeing this outright falsehood being dished out to the public. That's why you are seeing all this orchestrated campaign of calumny aimed at discrediting his personality, but they will not succeed. His popularity is the cause of all this. Rather than going to WAEC to obtain from WAEC that the result was forged, as was required by the Supreme Court, you are going to the pages of the newspaper, you are going to social media, you are going to media houses and all that. Please, I crave your indulgence. Let me just read this last portion of what the Supreme Court has to say in the Elebeke's case. The notion that a conclusion that a document is false or false can be drawn from the fact that the name of the owner in the document is stated in a manner or form different from how it is stated in other documents, or that a conclusion that the result of an examination is false can be drawn from the fact that it is differently reported in different documents, defeats the law that the forgery being a crime must be proved beyond reasonable doubt. And that is the court's decision in Mohammed versus Wamako on the kind of this is Supreme Court authority on what you need to do in proof. See, the allegation of forgery is criminal in nature. The standard of proof is beyond reasonable doubt. Evidence that would establish the allegation in this case beyond reasonable doubt include exhibiting both the document from which the alleged forgery was made.
Now,
and that was lacking. No, it's remaining two. And that is lacking. Evidence
you
that
have all the time.
No, with due respect, if I don't give these two, it will be half-baked. Evidence that it was the first respondent who forged the documents. The communication from the Polytechnic of Sokoto State disputing the first respondent claim to have studied. In this case, communication from WAEC is lacking. No communication from WAEC. You say communication from Polytechnic. This is Supreme Court speaking. No communication from WAEC. And nobody has come to say that these certificates are mine. These names that are not similar, they are mine. Don't forget that the given name, Francis and Oborevwori, reflects in all these certificates. There's nothing new. We are politicians and we know ourselves. If you go to the courts, several politicians go to the courts to reconcile different arrangement of names. It's a common thing. It's just because of his popularity, they are making a very heavy weather out of it. And I know that their case it will die on arrival in Court of Appeal. They know. They may have gone to the WAEC, and WAEC said this document belongs to this man.
Well, this is indeed an interesting legal battle.
Take the recent case of Obaseki. In the recent case of Obaseki, the Supreme Court said it's the issuing authority.
Ebonka, just a minute.
That can say that the document is forged.
It's an interesting case.
Thank you.
Which Nigerians are looking forward to, or as to how the appeal court will, eventually give its judgment.
Thank you.
But we must sincerely thank you for your time with us. It is indeed a pleasure having you.
How we shall have enough time to let you know what is happening.
And that's perhaps the reason why we brought you here for a rebuttal.
Thank you.
To also get the other side of the conversation. We must thank you, Honorable Barrister Victor Ebonka, Chairman, Ika North East Local Government Council, and Chairman Algon Delta State Chapter, also the National Legal Advisor of Algon in Delta State. He is also a member of the People's Democratic Party.
Thank you.
Good to have you join us.
Thank you. I appreciate you. Thank you. God bless you.
Oh, yeah,
Thank
great.
you. Thank you.
We'll go on a short break now, and when we return, the next conversation on the 2023 politics will be what we shall be talking about in our next conversation this day.